We've already started talking about the surge of unaccompanied alien children and the fact that there's a humanitarian crisis because the Office of Refugee Resettlement, or ORR, doesn't have enough shelters in order to house them. This week, I want to start talking about the legal programs that are available to help these unaccompanied children. Now remember, there is not a separate juvenile system when it comes to immigration court. So children are very often forced to face, albeit alone, the very same immigration court system and defend themselves against removal as if they were adults. Now, one legal program that may be able to help many of these children is a status known as the Special Immigrant Juvenile Status, or SIJS. In order to obtain SIJS, it's a complicated process. It actually involves 3 different legal processes, and I'll explain what those 3 legal processes are in just a moment. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. So there is a provision of the law known as the Special Immigrant Juvenile Status, or SIJS, that may be able to help many of the unaccompanied alien children who are being apprehended by Customs and Border Patrol, or CBP. SIJS is an immigration status that leads to permanent residency and could possibly lead to citizenship. In order to take advantage of this legal opportunity, a child must be able to show that they are a ward of a juvenile court, a state juvenile court, that reunification with one or both of their parents is not viable because of neglect, abuse, abandonment, or some similar ground under state law. Plus, the state juvenile court must find that it's not in the child's best interest to be returned to his or her home country. So, what does all this mean, and how can a child who finds themselves in removal proceeding in immigration court take advantage of it? Well, as I mentioned, there are actually 3 separate legal proceedings that you need to go through. The first is immigration court. What's important here is that immigration court does not have the authority to grant a visa petition. They don't have the authority to grant a visa. Immigration court may have the authority to adjust status or to address other legal arguments such as asylum, but it doesn't have the authority to grant SIJS. Nonetheless, SIJS remains a viable and potentially helpful status that may be able to alleviate the problem that an unaccompanied alien minor may have being in immigration court. So the first thing that you need to do is inform the immigration judge that this child is a possible candidate for SIJS. Then the judge will be able to continue out the removal proceedings in order to give you time to go through the other legal proceedings. But all the while, the immigration court proceedings will remain pending, and if there are hearings, the child will still need to go to court and attend those hearings and give the immigration judge maybe an update on how the process of obtaining SIJS is going. The second legal proceeding is to actually go into a state juvenile court and to get an order from that court that addresses the child's legal status. Now, I'm not talking about a child's legal immigration status. I believe any state court judge would be the first to say, that's beyond my authority, that's beyond my jurisdiction. We're talking about legal status, as in who's the guardian, who is the person who has the legal right to care for and make decisions for the child. And which courts have jurisdiction over this? Well, it's going to vary from state to state. I practiced in Virginia, and here we had the Domestic Relations General District Court. But it's quite possibly that in other jurisdictions you may have an orphans court or a children's court or a family court. It all depends on your local jurisdiction and what the law says. Now, when it comes to these unaccompanied alien children who are coming to the United States, in my experience, most often, the child is coming to the United States in order to be reunited with one of their parents, a parent who usually has come here first and then is sent for the child to join them. That means that in many instances, when I was going to the state court, I was going to the court to get that parent appointed to be the guardian or appointed to have sole legal custody over the child, as long as I had a state court order addressing the child's legal status. Now remember, the law says that we need to show that the reunification with one or both of the parents is not viable. Now what that means, it could be that reunification with just one of the parents is not viable. It doesn't destroy your case if you're going to court with the other parent and you're making allegations that the first parent is the parent that the child can't be reunited with. In fact, very often, what we're doing is going into state court in order to get a custody order and show why reunification with the other parent is just not viable. In my experience, many times the issue is domestic violence. A lot of times the mother has come to the United States first in order to escape domestic violence. And where you have domestic violence, very sadly and very unfortunately, the mother may not be the only victim. So a lot of times I was going to court with evidence of abuse or even neglect by the missing parent. I may have even been going to court to show evidence that the other parent just abandoned the child. Now, in some instances, I have been able to get a sworn statement from that other parent. It can be helpful in instances where, for example, you need to show jurisdiction or personal jurisdiction, or to show that you've given the other parent notice about their parental rights. Sometimes when you're doing that, you're able to contact the other parent, and the other parent may very well just consent not only to the court proceeding, but also to the fact that they're giving up their parental rights to the parent who's in the United States. Depends on your circumstances. Sometimes that can backfire. You need to know the specific facts of your case in order to know if this is a strategy that's open to you. Because otherwise, because you need to give notice to the other parent, sometimes you may need to do notice by publication. That is, putting a notice in a newspaper of general circulation and getting a certificate from that newspaper in order to establish jurisdiction. Otherwise, the courts are going to be very reluctant to give you an order that's cutting off a parent's rights. So, if you're going into court and showing that reunification with one parent is not viable, it is perfectly acceptable to go into court with that other parent, the one who is in the United States, and have that parent to be appointed the guardian in order to satisfy the requirements of SIJS. And let me emphasize, that's not exclusively going in and getting an order for the mother. I've had cases where the parent who was in the United States and the one who was actually caring for the child was the father. Really depends on the facts and circumstances of your particular case. Now, in addition, you need to show that it's not in the best interest of the child to be returned to their home country, which means you are going to need to show evidence of the home country's conditions, whether it's wrapped with gang violence, whether there is some other situation back home that makes it dangerous for the child to come home. You can do that, for example, through an affidavit from the parent who is petitioning to be appointed the guardian or to have sole legal custody. And that parent should be prepared to go to court and to testify as to why it is not in the child's best interest to be returned to the home country. Because very often the child is coming to the United States because they're trying to escape from some very dangerous situations. That could be gang recruitment, because once a gang has targeted somebody for recruitment, that gang is going to be persistent, and it's either going to end up with the child joining the gang or the child being murdered. So you will need evidence like that in order to go into your state court to show that the danger in the home country is just too great for the child to return to. So when you're going into your juvenile court or your domestic relations court, the point is you're getting an order from the court that is making certain findings with respect to this particular child. So as an advocate, you will need to go to the court and provide language, proposed language, to make sure that the court order covers all of the legal requirements. Once you have your state court order, it's then time to move on to legal process number 3. And that's before U.S. Citizenship and Immigration Services, or USCIS. USCIS is the agency that has the jurisdiction to grant a visa petition, which means you need to file your visa petition with that agency. In that petition, you'll need to allege the reasons why reunification with one or both parents is not viable. You'll need to present your evidence. And most importantly, you will need to present a certified copy of the state court order. This is also your opportunity to show evidence of the situation in the home country and why it's just not in the child's best interest to be returned there. USCIS will then schedule an interview. Very often that interview will be both with the child and with the guardian, for example, the parent who just won custody at the state court level. And if the child meets the requirements, then USCIS will grant the petition. But once USCIS grants the petition, that's not the end. That's because the law limits the number of these visas that are available every year. So even if USCIS finds that the child qualifies, the child will still need to wait until the visa becomes available, all due to these legal quotas. And once the visa becomes available, that's when the child can become fully legal, can become a permanent resident. Now, as of March 2021, a child who filed the petition in 2018 from the countries of El Salvador, Guatemala, and Honduras are just finding that their visas are becoming available. So there is a waiting period, and it can be as long as 3 years. All the while, the immigration court proceedings will still be pending. I can tell you that in my experience, immigration judges like to see these cases. They like to know that there is something, a pot of gold at the end of the rainbow for these children, and they're willing to continue out the cases as long as you're showing progress towards reaching that goal, towards obtaining SIJS. That could mean that you come into court with your copies of the state court order. Maybe if it's before you have actually had your hearing in the state court, you'll need to share copies of the petition that you filed. If you have your state court order, you may need to show your receipt from USCIS after you filed your visa petition with USCIS. If you have an interview date, having that notice of the interview date and being able to show it to the immigration judge will all be helpful in letting the judge justify and rationalize why he or she will be continuing out the case. And then, once the child has actually received the SIJS and has their visa, has their permanent residency in hand, well, then the immigration case is over. And then you go into court and you ask for it to be closed. It's over. It's done. The child now has the legal right to stay in the United States. And once the child has the legal right to stay in the United States, once they are a permanent resident, the child will eventually have the ability to apply for citizenship. And citizenship is a very important concept for a number of reasons. One is that even as a permanent resident, it is possible to be deported from the United States. That can happen, for example, if they run afoul of the law. It can very well be that something as simple as a simple possession of marijuana can lead to deportation. At any rate, another issue is that once the child becomes a citizen, that child has the ability to help the parent, assuming the parent doesn't have immigration status. It's possible for the child at some point to file for the permanent residency of their parent. That doesn't mean that the process isn't tricky. For one thing, child has to wait until they're 21 before they can file a visa petition for their parent. Second thing is that under current law, if the parent entered the country illegally, if they snuck in at the border, if they came in illegally in some other manner, not if they're an overstay, but if they came illegally, going to be very difficult to actually adjust in the United States. In fact, they're not going to be able to adjust in the United States. It will require them going back to their home country to process at the consulate. That adds a whole wrinkle of issues, such as whether a waiver of illegal presence is possible. That's very complicated. I'm not going to talk about that in this video. We may talk about waivers of illegal presence in future videos. The point simply being that once a child who is an unaccompanied alien child or a UAC has come to the United States, there are these programs that are available to help them, like SIJS. And if a child is successful in obtaining SIJS, then there are other opportunities, other doors that are open that may be able to help the child's family. And it's always best to consult with a qualified immigration attorney in order to explore all of the options that may be open to you or a child that's in your care. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.